Welcome to Lecture 6 in this series of lectures on practical tips for social justice advocates learning from the disability experience. My name is David Lepofsky. I'm a visiting professor of disability rights at the Faculty of Law at the University of Ottawa. We've talked already about the landscape for doing advocacy within the disability communities, about strategies for building common ground within an advocacy constituency, selecting the platform or organizational base from which you're going to do advocacy, not only on how to build common ground, but how to develop a core message, an agenda, and ultimately a brief, a document that in some way or other explains what you're looking for, why it's good, and why it should be adopted. In our last lecture, I shifted from talking about what you're seeking to how to get it. And that's going to really be the focus of all the remaining lectures in this series. In the last lecture, I talked about basic tools in the advocacy toolkit for the social justice advocate, and I described several that at least I use, and I know other people in varying degrees use. Today, I want to focus on something a little more unorthodox. I want to look at illustrations of avenues for social justice advocacy that on their face may not look very productive for you at all, and you might well think they're not worth your time. In fact, I'm going to give two illustrations where I specifically didn't get involved in them for a long time, because I thought they weren't worth my time. But on reflection, they are actually really worth it. I want to describe them, tell you about my experience, and offer you some action tips you can learn from my experience in these. These, in both cases that I'm going to give you, are examples of government-appointed advisory committees. Now, why was I reluctant to get involved in any of these for the longest time? I was reluctant for a number of reasons. First, all they do is give advice. They don't actually make any decisions. So I figured, why spend all that time just coming up with ideas from advice if people don't listen to you or don't have to listen to you? I feared that in some cases they may be just performative. A government agency or an airline or other may appoint these so they can say they have one, but they don't really listen. They want to be able to just point, make people feel important while they're on the committee, make them feel like they're actually being taken seriously, but it doesn't really change anything. And so on. So I figured, you know what, I don't think it's worth my time. But I think it's worth being more nuanced. We should look back at these, if there are opportunities, and say, can I productively use these for our advocacy advantage? That depends on how they're operated. If they are confidential and secret, if they meet behind closed doors and they're the subject of non-disclosure agreements and requirements, you're not allowed to tell anybody about them, frankly, I wouldn't likely get involved at all, because then they are the kind of thing which a cabinet minister or other organization can proudly point to and have photographs of, look at all the people we consult. But if you give them advice and they don't listen, there's no recourse for you. You can't really let anybody know. I want to take part in one of these organizations if they are capable of being an effective platform for advocacy, whether or not the organization that appointed them means them to serve that way. And let me give you the two illustrations that I will spend my time talking about. The first is a special education advisory committee, in the case of the one that I've been on for 10 years and now chair, the Toronto District School Board Special Education Advisory Committee. And the second is the provincially government-appointed kindergarten to grade 12 Education Standards Development Committee, appointed under the Accessibility for Ontarians with Disabilities Act. So let me turn first to the Special Education Advisory Committee, or SEAC. In the Ontario context, by the way, both of these relate to a theme that we're focusing on as an illustration in this course, and that is trying to advance equal opportunity for students with disabilities in the school system. So what is a SEAC? For quite some time, Ontario law has required every school board in Ontario that receives government money to appoint a special education advisory committee. And its mandate, set out in a regulation, which I'll link to in connection with the materials in connection with this, this video lecture, its core mandate is to give advice to the school board at the elected trustee level, where there are elected trustees, and the senior staff of the board on how to improve education for students with special education needs. Who is on this committee? Well, a regulation enacted under our Education Act sets out its mandate and its structure. It is made up of in school boards that have elected trustees, which at the time of recording is supposed to be all school boards except 8 of our boards have been taken over by the province, and we're advocating to get that changed. But in any event, there are 3 categories of members. They all have equal voting status. One is representatives of organizations of parents of students with special education needs. So there are several associations, they're called, but organizations that made up of and advocate for parents of kids typically identified by a particular condition. There's an organization of parents of visually impaired kids, an organization of kids who are deaf. There's an organization that advocates for kids with intellectual disabilities, and so on. It also, because our special education legislation includes gifted children, whether or not they have disabilities, it includes a representative of the Association of Bright Children, kids who are gifted, whether or not they have a disability. Now, that's the first category, and those representatives are not chosen by the school board, they're nominated by the organization. They send the nomination in, the school board's supposed to just approve it. The second category that could be of members that could be on these committees is a community representative, individuals who put their name forward and say, my child goes to school at this school board, and I am living in the community, and I'm their parent, and I would like to, my child has special education needs, and I would like to be on the committee. And the board can select a certain number of those, and there's some flexibility in that. And where there are elected trustees, there can also be members who are actual elected trustees from the board that governs the school board. What are the powers of the committee? First, they can give advice either formally through formal motions that they pass, or informally, just at a meeting, go around the table and give suggestions to staff and the board. Second, every school board is required annually to file with the province a document called a special education plan. It's actually not a plan, it's just a report on what they've been doing or what they say they're going to do. And the board is required to consult with its Special Education Advisory Committee on its contents. Third, the Special Ed Advisory Committee, or SEAC, is required to be consulted on the school board's special education budget, and it actually has a right to see the special education budget documents or statements of the board. The committee is supposed to meet monthly, except during the summer. The committee elects a chair or vice chair from its members. The school board staff are supposed to provide administrative support to the committee. The committee does not consider individual students' cases. It's not like a parent can come to them and say, this school isn't accommodating my child needs, would you please tell the board to do it? Rather, they can give advice on systemic problems or recommend systemic conclusions or give advice on changes the board is considering. Now, why was I so reluctant for so many years to get on one of these? Well, like I said, nobody has to listen to them. And I feared that these would be viewed by the school board, as I think they are, as largely something that provincial law requires them to have. They're kind of performative. There's a term in government, stakeholder management. That means, look like you're listening to stakeholders, in this case parents, and give them a chance that they're to feel like they are, while at the same time trying to manage their expectations and manage criticisms and so on. My worry about these were also manifested when I first got on the Toronto District School Board Special Education Advisory Committee back in the spring of 2015. Now, the TDSB is the biggest school board in Canada. It has 250,000 students. It has over 40,000 students with disabilities and special education needs. And what I found out when I got there is that the agenda for our meetings was set not by the committee itself, but by the staff, the school staff. And I found the committee was filled with, agenda was not filled with giving advice on important issues, but rather was just kind of busy work. Hearing kind of show and tell presentations about the good things they're doing and so on. And I was aware of that. One of the other worries when you're on one of these committees, depending which one it is, the members on the committee may be committed to the idea of advancing interest of students with disabilities and special education needs, but depending who they are, they may not know anything about how to do advocacy. Some organizations, including some municipalities, will tell their municipal accessibility advisory committees that they're not even allowed to do advocacy. You can give us advice, but don't advocate, as if there's some kind of difference between the two. There isn't. What are the tactical advantages of getting on one of these committees? Well, in the case of SEAC, they meet publicly. And the members of the public can attend. If you can stir up media support, you can get journalists attending. And at least up until a few months before I gave this lectures, they could be live streamed. Now, since the provincial government took over 8 boards, including the Toronto District School Board, and ousted their elected trustees, at least for now, we don't know their future plans, the province directed that school boards can't live stream. School boards under provincial supervision can't live stream their meetings. We've objected to this publicly and gone to the media about it. Other school boards can stream their live stream their meetings. So parents can watch from home, journalists can watch from home. It can be archived and then referenced in the future. These become a public platform to raise disability concerns and to ask staff to answer questions in a public forum. And even if the answers aren't satisfactory, that can and has been a basis for more advocacy. Another reason SEAC can be a useful avenue for advocacy is if they make a formal recommendation to the board. Under the regulations, SEAC is entitled to be heard by the elected trustees before a decision is made on their recommendation. And so in my experience, for example, and I'm not the only one, but in sharing our particular SEAC, I have gone to the elected trustees at a number of meetings and went and presented a concern that we've raised. Now, I won't do that unless I've first tried to resolve it, and we've all tried to resolve it with staff of the board. If we can get change without going to the trustees, of course, we'll do that. But if the staff, senior staff are resistant, then the avenue of going to the trustees was another avenue. This, again, no guarantee, but at least it's an avenue for persuasion and an avenue to get media attention, because even if media don't cover your SEAC meeting, they may cover the whole school board's meeting. Now, what problems have I encountered in this, trying to use this as a platform for change, and what have we done about it? The first problem I found is that school boards here in Ontario are basically run not by the elected trustees, but by the senior bureaucrats. all the way up to their CEO, who's called a director of education. And I have found these trustees may be well-intentioned, may be hardworking, but any public servants at the head of a large organization need accountability, need public accountability. And I have found that, at least in my experience, there is a tendency, unsurprising, that they try to diminish what SEAC thinks they can do and tell trustees you can't get involved in operational issues, which is nonsense, and so forth, to minimize the amount of oversight they get, either from the trustees or, frankly, from us. This problem has gotten worse in boards where the provincial government has ousted the elected trustees. And I've done advocacy with others on this, because when you take away that public accountability, you have senior public officials who are now essentially reporting only to a provincially appointed supervisor, not to folks who are locally elected. How do you use a SEAC as a platform for reform? The first thing you got to do with any of these bodies is, using the ideas I've shared in an earlier election, look at the legislation, look at the regulations, figure out what you're entitled to do. Sometimes you are told by the staff things to limit your mandate, which are simply inaccurate, and I have had to shoot back. For example, we've had senior staff at a meeting say, SEAC can't deal with operational matters at the board. And I've said, no. Read the regulations. We can give advice on anything to deal with the design or delivery of special education at the board. That's all operational. And my colleagues on SEAC agree. So it's important to be armed and equipped to know what you're entitled to do, because you may find the staff you're advising, rightly or incorrectly, try to minimize what you can do. I've gone through the list of our various powers, but one of the most important things we can do is pass a formal recommendation, a public formal statement of some change we want. What did I first found when I got to SEAC in 2015? Well, I mentioned earlier that the agenda was so preset that we didn't get much chance to give input. I found my colleagues, the other members on the committee, were very frustrated. They're there to give advice. They have serious concerns, and they were finding that they couldn't find a place to voice their concerns. The way the meetings were being run when I got there was that the staff worked up the agenda. Somebody had been elected as a chair who simply took the agenda, ran the meetings, and well-intentioned individual, very dedicated individual, but that's all that happened. My strategy went like this. First, as a member of the committee, when I saw what was going on, I came forward with a proposal. I said, why don't we set up a priorities committee? Let's figure out what matters to us. And I offered to chair it, and nobody was opposed to this. We got a couple of members, including our chair, on the committee. And what we did is we would take a chunk of time at the committee meeting, at the overall committee meeting, and went around the table using strategies for common ground building that I've referred to earlier. And I had everyone identify the kind of things that they thought were really important, not fancy in terms of wording, in terms of the agenda. I said, what would you like us to talk about? Just plain language. And taking their temperature, I found this was actually the first time for some of them that they'd ever been asked this at this table. I found their tone of voice picked up. There was a certain growing enthusiasm about being able to do this. I drafted what I thought were, using the common ground building features that strategies I've talked about in an earlier lecture, came up with a short list of priorities, 3 or 4, and said, why don't we work on these? And I suggested we could always stay flexible to add more, but at least it gives us some focus. And then suggested that that be the focus of our efforts. Well, by the time that process had wound itself up and we had real buy-in, I found the opportunity to run for the next chair of the committee, and I was chosen for that role. The first thing I did when I became chair is I took over the role of setting agenda. I told the staff, I know you used to set the agenda, from now on, I'm setting it. The bureaucrats weren't necessarily happy with this at first. They were used to just putting things on the agenda. And when they sent me things that they want on the agenda, I'd say, okay, why do you want this? And how much time do you need? And maybe this is something we can deal with by email rather than taking up meeting time. I viewed our 2 hours a week, our 2 hours a month together as precious time, a scarce resource. I want to use it on major topics that were of most importance. One of the things I also did was I found that the staff were filling the agenda with a whole lot of tiny little items that were 5 minutes, 10 minutes, 5 minutes, 10 minutes. And instead I said, let's just take 3 or 4 topics per meeting and let's dive into them and deal with them seriously. Let's pick high impact topics using our priority list. In fact, what I did is I said, we are going to undertake a review of special education at the Toronto District School Board. We didn't need any legislative mandate. We didn't need any approval. We just did it. How did we do it? Using that priority list, we picked topics that would be of high interest to the most parents and the most kids the most quickly to get started. And I'm going to give you an example of what we did and steps that it took a little later on, because I've got a really good illustration of this coming. But we'd raise a topic. The first I would do is kind of identify it in plain language. And then we would invite staff to a meeting to come in and brief us about it. If it's the topic I'm going to talk about later, how parents learn about what's available for kids with disabilities and special ed needs at the board, how do you tell people about it? What's the board strategy? We invited staff to give us a briefing. And at a meeting, I gave them the heads up so they could plan in advance. Staff came in, they brought in whoever they wanted, and they explained it to us. We then went around the table and people got a chance to ask questions and raise concerns. In the process, you could ask for any school board protocols or policies or directions or anything that they've previously done in this area, something to bring you up to speed. If they can't answer something on the spot, I'd say, hey, look, if you can't answer it right now, can you come back at our next meeting and let us know? So I wanted them to know that our questions were serious. The committee really chimed in on this. The next step is to have a roundtable with just the committee members. The staff are listening, but go around and say, is this good enough? Do we need more? Is it working? What do you think? And not with a vote at the end of the meeting, but just a chance to, again, take the committee's temperature, kind of like brainstorming. While I'm doing that, as chair of the committee, I'm applying the Build Common Ground strategies I've given in a prior lecture. So I'm looking at what can be the sweet spot that folks would be able to agree on. As we're finding that, we can then turn back to the staff and say, look, we've identified these concerns and these problems, and people are raising various ideas. Staff, will you come and brief us on what you think? Do you think that these are problems? Do you think what solutions do you think might work? Now, staff may be willing to do that, or they may be nervous about saying anything publicly. That depends on the people and the issue. If staff will work on it, if they genuinely will work on it, will go away and work on it, then my approach is to say, okay, why don't we defer this to a future meeting? We had that when we had a presentation at one point by an outside presenter about the problem that a number of us had not previously known about. And the board brought in I asked the board to bring in a staffer to describe what they're doing about it. And a staffer came in at a future meeting and said, look, we have no policy on this. It's a real problem. And he said, we've got to do a policy. Well, I didn't want to proceed to a motion at this point or a formal written recommendation. I said, well, okay, why don't you come back with what you think you can do? and as a draft, and then let's talk about it. And they did. And they came back, and when we gave some feedback, they said, let us go away and work on it more. This went back and forth several times, and it was a really constructive process. And what happened in the end was they adopted some of our ideas, didn't adopt some of our ideas, but we then put together a motion that set out the other remaining things we thought should be in it. And it was ultimately a very constructive process. If, on the other hand, the school board staff aren't prepared to engage in that process, they say there's not a problem, or we think we're doing enough, or whatever, then the next step that we've used is to proceed to a motion to the school board trustees. How do we do that? Again, there are no rules, but I draw on the principles I've been outlining here. And in fact, my experience doing this has actually helped inform the way I've described them in these lectures. So my first step is in drafting a motion is to go away, start write two parts. The preamble, where I summarize the problem. I'm not big into whereas and whereas, but some people like that kind of formality. But basically, describe the problem, and then describe what the board's doing, and describe why it's not good enough. And then, therefore, we recommend as follows, and then write out the recommendations using all the principles I've described before. Plain language, terms that I hope everybody would find compelling, things that the board would not be able to say no to, even if they don't want to say yes to, and so on. Then I circulate it to my membership by email and invite them to write me and give me feedback. And if there's anybody individually who I know is particularly fuming about this issue or whatever, I might call them up and say, what do you think? And then see if I can deal with things. If people email wording suggestions, I try to fix them before we even get to a meeting. And then at the next meeting, I call it as an agenda item, not for a vote, but just to go around the table and say, okay, I sent out a draft, got some of your feedback, but maybe you didn't get a chance to look at it. So I've revised it in light of the feedback I got. Here it is. Anybody have thoughts? Let's go around the table. And again, you're taking the temperature. If there's something that is controversial, if there's something you need to fix, something you need to delete, whatever. And then after it's done, go away and see if I have enough time, go away and see if we can come up with a final draft. And hopefully what'll happen is I will send out a revised draft, hoping it's the best. It incorporates everything, send it out to everybody, email, say, next meeting, I'm hoping to have a vote on this. If you have any final concerns, please let me know. You're, of course, welcome to raise them at the meeting, but we want to bring this to a conclusion, so let me know in advance if you can. More often than not, by the time we get to the next meeting, the motion passes, often unanimously and quickly. And I'll say, anybody else want to speak? People feel like they've had their chance. Once I've done this, the next step is to take that motion and present it formally to the elected trustees. Often this requires you to go first to a trustees subcommittee or committee. Those are live streams, so you can go in person or do it on Zoom, and people can watch, and then you can use social media to publicize with a hyperlink to the pinpoint point in the meeting where you were reached. I view those meetings like, for want of a better term, like a long closing argument in a case or jury address. Not that I ever did jury addresses. In other words, I go to present my particular motion that I've been mandated by my committee to present and make the cases. But what I'm also trying to do is build a relationship and build credibility with the trustees. So even if they don't adopt this one, I can come back later with another one, and I've been building it. I also like to go on the easiest one first, the one where there's least likely to be credible opposition, before I bring more complicated or challenging topics in future meetings. And once, on a motion that I would have thought was non-controversial, I had a board chair who said, we aren't entitled to go to speak to the whole board. By the way, recent years never happened. never been a problem. But at this point, I don't know who told who within the board staff or whatever, or within the board governance office, that we're not allowed to speak to the whole committee. And I wrote them and said, here's the terms of the regulations that specifically say that we can. And they were going to say no. I looked at it, and the lawyer in me said, well, can we apply for judicial review and go to court and fight this? Well, I don't want to do that. I don't have to find a lawyer. It could cost thousands. It could take months or years, and it'll be moot by the time we get to it. So found a somewhat quicker solution, calling a couple of reporters that I have a relationship with, told them about the Toronto District School Board trustees that were chair, who was refusing to allow our Special Education Advisory Committee to even speak to the board at a full board meeting. And after a couple of those phone calls, it didn't even result in a story in the press because the board backed down and I got to present. And ultimately on that issue, the board was happily supportive on the issue we were presenting. Now, why go to a subcommittee first? I had real trouble with the fact that the board had a policy that we can't raise something before all the trustees before we raise it to the subcommittee. My position was that the board's process, where a committee can either pass something and that goes on to the board, all trustees, or not pass something, at which point it either doesn't go at all or it's just noted in the agenda, could allow a minority of board members to suffocate a point and not allow us to speak to all trustees. And the regulations provided to us assured to us that we could get a hearing by the trustees. Haven't had to have a full fight on this. What I've done instead, at least lately, is to bring the matter to the subcommittee or committee of trustees, present it there first. I consider that a practice round. It's got 2 or 3 advantages. One is you can win over some trustees, which will be a base that we can try to expand when you go to all the trustees. The second advantage of it is that you can draw the staff out and have to respond to why they don't agree with what you're proposing. And sometimes they say things which, let's say, frankly, can help you very much in fine-tuning your argument and presenting to all the trustees. And finally, it's an opportunity to seek media monitoring and possibly media coverage. Now, how's this all working? Well, I will tell you that we have an agenda for reform that we've been able to press. We've made some improvements, but nowhere near what we should. But we are our efforts have stretched well beyond just what we've been doing in Toronto, and I'm going to give an illustration of that in a minute. Let me now move to the second unusual avenue for advocacy in which I took place, the K-12 Education Standards Development Committee, which the provincial government appointed to decide what an education accessibility standard for students with disabilities should include. Now, what the heck is a Standards Development Committee? I've referred at various points in these lectures to the Accessibility for Ontarians with Disabilities Act, a law passed in the Ontario legislature in 2005, and I had the privilege of leading the campaign from 1994 to 2005 that led to its enactment. That law requires the government to lead Ontario to become accessible to people with disabilities in really all major aspects of life, in access to buildings, goods, services, facilities, employment, and so on. And it sets a goal, which was 2025. The government failed to meet that goal, but we're still fighting. And the way it works is it provides that the government is required to enact and then enforce a series of regulations called accessibility standards. Now, by standard, it doesn't mean it's optional. They're supposed to be mandatory. And the government has enforcement powers, though they've been using them inadequately. And that standard should, in a particular sector of the economy, whether transportation or employment or whatever it may be, sets requirements for what must be done to remove and prevent disability barriers, and when it's got to be done by. Well, where do these standards come from? Under the AODA, the Accessibility for Ontarians with Disabilities Act, the government of Ontario, the minister responsible, is supposed to first decide we're going to make a standard in a particular area, like education, and then he or she is supposed to appoint an advisory committee made up of representatives both from the disability community and from the regulated sector. In the case of education, that means representatives of the disability community and from educators, and so on. And they are supposed to make recommendations of what the standard should include. Their recommendations, when finally submitted, are required to be made public. And then the government can enact some, all, or none of what they recommend, or vary it and enact something else. So where this fits in here, my coalition and I in a leadership role, starting in 2009, decided that we need an education accessibility standard to tear down the barriers facing students with disabilities in kindergarten and grade 12 and post-secondary, college, university, and other contexts. Well, first thing we needed was to get the Ontario government to agree to do that. Well, it took a long time. Started in 2009. Wasn't until December of 2016 that the then Premier of Ontario, Kathleen Wynne, announced that the government would do this. Over that time, what did we do? Well, we built support for it from the disability community, and using the strategy I talked about in the last lecture, an open letter. An open letter was delivered to the government and made public in a newspaper article, calling for this from major players in the disability community, major organizations. But also, we wanted to get on side, use another one of the strategies I've mentioned, finding allies. I was worried that the government would think, oh, if we do this, maybe teachers would push back. So we approached the major teachers' unions in Ontario over those years, and we actually got the major teachers' unions to each write the Premier of Ontario. We made these all public in AODA updates, and they all separately endorsed the idea of an education accessibility standard. So I was able to go to the Premier and say, hey, we've got the major players who are on the front line of the school system agreeing with us that we need this. Why did we need it? We needed to address the barriers I talked about in the second lecture in this series about the barriers in the disability community. And I gave examples of barriers specifically in the education system. And using a strategy I will talk about in the last couple of lectures, by the way, the day that we brought this story forward, we got the Premier to agree that morning. The story about our open letter that had been sent to her that morning, she'd heard from us before, but that was sent to her that morning, was published in the Toronto Star, major newspaper, because we'd given an exclusive to the education reporter there to publish it that morning and report on it. More about getting exclusives in the last couple of lectures. Now, so let's move forward from 2016, when the Premier finally says yes, to the first mandatory step, which is appointing an education accessibility standards development committee. Now, the government made a wise decision early on. They said, this is too much for one committee. We should have two. One to deal with kindergarten to grade 12, and one to deal with post-secondary. Now, there had been other standards development committees in the areas of transportation, employment, the built environment, customer service, and so on. I had never gotten on one. I was reluctant to get on one for all the reasons I gave before about my reluctance to get on a SEAC. I was also reluctant to get on one because I figured we could have more impact from the outside, just making submissions to the committee about what should be included. And I didn't want to be tied to a committee in case I disagreed with them. But it occurred to me over time that I was wrong, and that frankly, we'd submitted briefs to any number of these committees. You'll find them at aodaalliance.org/briefs. And rarely did we have much impact. So I figured maybe it's time to get on the inside. So I applied to get on the K-12 Standards Development Committee. Uh, I ended up getting appointed, but there was a battle before we started. And it's an important example of the kinds of battles that we need to be ready to fight, even if they seem low visibility. I found out that the government at the time wanted me to sign a non-disclosure agreement. In other words, I couldn't talk publicly about what happened at the committee meeting. This struck me as ridiculous. We're not talking nuclear secrets. We're not talking about individual students' files. We're talking about public policy. I'd also heard from other committee members on other standards development committee that this non-disclosure agreement made it harder for them to consult within the disability community, and they're there to consult with members of the disability community and bring their concerns to the standards development committee table. So this seemed absurd. So I dug in. I said, you've appointed me. I'm making it public that you appointed me. I'm not signing an NDA. And we had a bit of a showdown, and finally they backed down. I didn't sign the NDA, and I got on the committee. Now, at this point, all the other committee members who hadn't known that this was even an option had signed it. And I just told them, I didn't. But then that particular government was defeated. A new government took over under Premier Doug Ford. A new minister took over. I raised the concern with them, and they actually had everybody re-sign without a non-disclosure agreement altogether. Otherwise, I wouldn't be able to talk about what I'm going to be talking about in this video. Now, we had half of the committee was members of disability, half of the committee was members of educators. The design in this is very much, in my mind, when we lobbied and got the Disabilities Act to include this, was that this would not only be a place for trying to build common ground, but think of it like trying to negotiate settlements to like a million discrimination claims when there are no claims, and when there's no litigation and no warfare and no dug in, and just try to anticipate what the concerns would be, try to figure it out. At the table are people who are experts in what people with disability need, and that's people with disabilities, and experts on how to incorporate such measures in the education system, and that is teachers, school board managers, trustees, and their representatives. I was the only lawyer at this committee table. I wasn't there as counsel, but I found out quite quickly that there was the other committee members, who were wonderful people, did not understand some core basics. It took me a while, actually, to really come to realize this. I wish I had been perceptive to it early on, but I found there was little understanding. We were there to recommend what should be in an accessibility standard, but there was a little understanding of what the Disability Act accessibility standard is supposed to include. The staff gave some briefing, but it didn't really, wasn't delivered in a way that had it really sink in. I understood this stuff because I was involved in lobbying for the legislation, and heck, I'm a lawyer, and this is a field of law that especially interests me. But, excuse me, lay people don't necessarily know this stuff, nor should they. The other thing I found over time is that my colleagues at the table may have heard about the duty to accommodate people with disabilities, but didn't understand the details of it. Well, I litigated cases in the area, written in the area, I lived the issues, know a reasonable amount about it. But it took me a while to come and realize this. And as well, the Disabilities Act is supposed to be, and the Human Rights Code, our anti-discrimination law, are supposed to be paramount over all other legislation, as is the Charter of Rights. That means it's paramount over the Education Act. I found that the mindset at the table is very much, well, we can't do X, it may not be consistent with the Education Act. Well, it's the other way around. The Education Act has to give way, not the other way around. Similarly, and finally, those of us who practice law, when we're in law school, we have to take a course, or often take a course called Administrative Law, which talks about legal principles that overlay the operation of things like the Education Act. I knew that stuff. I had to know it for my practice. I had to do it to know it to get to become a lawyer. But on the other hand, I had a number of colleagues at the table who I came to realize didn't really know it. And sometimes things came up and they wouldn't appreciate that context. No, these aren't uneducated people. These are not bad people. They're wonderful people. They're dedicated people. They're energized people. But it's not fair to expect them to know this. I ended up having to do a couple of things. I lobbied to get us to get presentations on these topics by the Ontario Human Rights Commission and by our major disability rights legal clinic, the Arch Disability Law Center. And the other thing I had to do was I had to sort of take it upon myself, unannounced, to try to gradually inform my colleagues on the committee about these core legal principles as they applied. Now, I can't sit there and go, hey, you all don't know about this, but I do, and let me tell you what I wish you knew. If I were them, I'd think I was an idiot, and an arrogant one at that. And so I had to do it kind of gently, slowly, and delicately. I found, as I said in my opening lecture at several points, I really had to build my own personal credibility with them, one step at a time, one issue at a time. I even got to a point where the committee had been told that we could not make recommendations that were specific. They all had to be general. This was completely wrong. But for me to stand up and say, that's completely wrong, and let me give you my 5 arguments like I would do in a courtroom, would alienate people. So I had to deal with it kind of in a gentle and a careful and a gradual way. The other thing I found that was going on at this committee early on, at the very start, is that the ministry staff who were supposed to support our committee were very much micromanaging our process. And very much controlling our discussion, even to the point where they sent in a facilitator to run some of our discussions and meetings. And this was a facilitator who knew absolutely, was not a lawyer, did not know law, did not know disability, did not know education, but was one of these sort of facilitator types. Nice guy, but he didn't know what he was doing. And I had to see that I saw things were going to go nowhere. This was going to go nowhere fast. When the new government took over in 2018, they happened to have an agenda of saving money every which way. So I went to some of the senior people at the ministry. I said, you want to save money? We don't need so much staff at our Standards Development Committee meetings. Let them just take minutes and facilitate the tech. Let us do the discussing. And they did. And it actually worked very much to the benefit of the committee. From then on, we were kind of running our own show. And it really enabled us to do better. Under the ministry lead, they decided to break us into 7 working groups to deal with different subjects. I was asked to lead one on built environment in schools. I was assigned to one. But over time, I decided I was really interested in each of them. So I approached each of the groups. And with maybe one exception, they all agreed and said, David, will you come to our working group meetings? And I said, sure. So I went to almost all of them and was able, just as a collaborative exercise, to work with them and help address concerns. Now, here's a weird one. Nothing in the legislation said this, but the ministry adopted a rule that said we could not pass a recommendation unless 75% of our members agreed. Now, again, a legal analysis, you might argue they don't have the statutory authority to do that. Maybe I'm right, maybe I'm wrong. But I'm not going to go waste two years and a ton of money litigating that and slowing up the whole process. I was mad about it because I was afraid it would dilute. If you need a broader consensus, it would dilute what we were able to agree on. It ended up not hurting us at all. In fact, I'm going to give an example a little later where it actually led to a better result, notwithstanding my very strong, strenuous, principled, passionate objection to using the rule. And since our work has been done, I've been able to go public with our report and say, hey, this is such a strong consensus document, we couldn't pass anything without 75% approval. When it came time to develop our final report, here's something which was a strategy that that hit me, which is entirely counterintuitive, but I'm really happy with it. Our report had been written by these 7 working groups or subcommittees, and each one had a very different writing style. And each of their parts came back to the whole group and were tweaked and massaged so that everybody was happy with them. Not because I wasn't leading the process, but it ended up using the same kind of consensus building strategies or why did I say that? Common ground building strategies that I've been referring to. And, but the problem with the document was it was not well worded. It was not well written. It was readable, but it was different writing styles, and there was probably at points verbose, and so on. And the ministry or the committee chair or somebody proposed that they hire a writer. Now, you'd think intuitively that makes sense, but I opposed it, and I managed to get the committee to stop it from happening. Why did I oppose it? Well, because I know that when government reports like this from advisory committees have come out from elsewhere, the staff get involved in how it's worded, and sometimes it gets sanitized because they're, I don't think they're Machiavellian, but they may be very worried that the government's senior political people don't want us to go into a particular area or tone it down, and they may send it to their communications people and all this sort of thing. I was very afraid that we were going to lose substantive content. And so I opposed it. And the way I managed to argue the case to my committee was to say, look, if this thing goes to some writer, we are going to have to go through it line by line. And it was long, it's about 180 pages, to make sure it says what we wanted it to say. I mean, one thing is cleaning up punctuation, but another thing is changing the words we use. And we had just gone through such an exhaustive process of looking at each chunk and addressing wording concerns that people had. I said, that could get all undone. And I don't want to do it. We don't have the time to do it, but I will be looking at every single paragraph. And the committee was really determined to get our report out as soon as possible. We'd worked for 4 years on it, and it was agreed, let's just let it go as is. The benefit afterwards, before I give you a couple of examples, well, there's several benefits to all of this. The report was made public or was released in January for the government in January of 2022 4 years before the time I'm giving this lecture. It was made public a few months later, even though legislation required it to be made public upon receiving it, maybe a few weeks later. But in any event, I was able and am able to say the following about this report, even though the government's enacted nothing in it so far. It totally constitutes the blueprint we need. I describe it as the most in-depth study of investigation of Ontario's school system from the perspective of students with disabilities in all of our lifetimes. And that's a fair statement. Moreover, as part of the assessment of developing it, under the legislation, we were required to make public an interim draft and get input from the public, and then review that input and then finalize our report. We got about 250 or more pages, single space of feedback, and we all read it. I read every word of it. And what we did is we heard from educators, and we heard from parents of kids with disabilities, and we heard from educators who were parents of students with disabilities. And there was an overwhelming consensus that the problems we identified are real, the barriers we identified are serious, and the general direction of our recommendations were really good. Yeah, some people would have wanted a bit more or less here and there, but the overall direction, we could say that this report reflected a real consensus, not only from our committee, 75% or more supported it, but also from the constituencies whose respective concerns we were trying to balance. What was very interesting as we went is I kind of went in with this predictable expectation that it's going to be two sides of the table, the disability side and the educator side, and we're going to be at loggerheads. turned out that the two of the leading people on the committee from the school board side, a representative of the Public School Boards Association and a representative of the Catholic trustees, the three of us not only got along really well, but found the common ground working with us that the rest of the committee in a number of areas were prepared to accept, both because it was good and because they saw that we had brokered it. And I'm not saying we were the only ones or I was leading it. It was very collaborative. The other thing is the fact that it isn't that well written has worked to our advantage. I've said publicly about this report. The contents are all good. Now, it may not read as well as if it was not written by different members of a committee, but it shows that this is really a core effort of these people, not somebody doing a sanitized version of it. So that's really worked. Now, let me turn to one last area to wrap this up. Let me give two illustrations of activities I've been involved in, one at the Standards Development Committee table and one intersecting both of them to show the possible ways to use these platforms. First, the Standards Development Committee. We were actually at the point where people were pretty much in agreement on everything we were recommending, but there was one issue which under this 75% was defeated. And it was defeated on a vote where in favor of it was 69%. I was livid. 2/3 of the committee supported, but we can't proceed with it. And it was the issue of what would be our recommendations of what to do about students with the autism if they bring an autism service dog to school. It turned out, and I was fuming, like this ought to be the subject of a consensus, and why are we this, and the rule's not fair. Anyway, what did I do? I decided personally to appoint myself to do a mediation process to try to find a solution. I didn't announce it. I didn't seek permission for it. I didn't need any permission for it. I simply called up the people who voted no and asked them what their concerns were. And these are straight mediation principles out of Getting to Yes by the Harvard Mediation Project going back to 1981, 82. And I listened to them and asked them about their areas of concern. I then called the organization that trains autism service dogs in Ontario, and I went over with them at great length what the concerns were and got their answers. I then called up the no voters and anyone who was even on the fence, and went over the answers and said, do you want me to set up a meeting with these folks and stuff? But they were sufficiently, but through these discussions, I was able to identify revisions to the recommendations that we had defeated that actually would accommodate the concerns of the no voters. And as it turns out, made the recommendations better and stronger. And when we brought them back to the table, they passed. I think there was one vote against. I think it might have been somewhat performative in the sense that it was an individual who was personally with us, but the institution or organization they were representing couldn't be on the record saying yes. I didn't care. It went through, got well over 75% approval. Nobody's criticized it since the report came out 4 years ago. And it's a good piece of work. So it's a good product. So in the end, my objective, that 75% rule and the defeat of it, turns out they all worked to our advantage with the end product. The other example I want to give you is, I want to take you back to the Special Education Advisory Committee, then back to the Standards Development Committee, and back to the Special Education Committee again to see how this can all interplay. So remember I said that when I became chair of the Special Education Advisory Committee back in 2016, I wanted to pick topics that we could work on. Well, one of the ones we worked on first, I call the parents' right to know. What is the school board doing to explain to parents of kids with special education needs what's available for them at the board, what programs, what services, what supports, and where to go to get them? Turns out that lots of parents find it really hard to find this out. I describe the TDSB as like a restaurant that won't give you a menu but expects you to order. And it's enormously frustrating. So I raised this at TDSB. So we followed the procedure I talked about earlier in this talk, invited staff to come in. Tell us what you do to explain to parents. Well, we have the website, and we have pamphlets we give out, and we have our special education plan that they can look at, and which is very detailed. And they said, and you can call the school principal. They're your lead point of contact. Well, the feedback from us was this. Number one, the leaflets or pamphlets don't tell you much, and they're written in obtuse special education lingo. If you don't know all this jargon, they're not very helpful, and they don't answer some of the key questions like what's available and where do I go to get it. Telling us to look at the special education plan, back in 2016, it was about 200 single-spaced pages. And it's full of technical, it's a provincial filing that they have to make. It's not written to be user-friendly. Frankly, it is not a useful tool to find out what I should get for my child because my child's having a tough time learning. I may not even know the label applied to it, and I don't know where to go to look it up to find out. The website. I actually got a couple of volunteer law students to go to that website, pretend that they have a grade 10 education, and they are a parent, and try to find where this information is on the website and how informative it is. Well, it was extremely hard to find. It's, again, like the leaflets, written in obscure jargon and not written in plain language. And it largely didn't answer the key questions that parents are going to want to ask. So we went back to the board and said, this is a problem, you need to fix it. And the other thing is principals. TDSB has 250,000 students, 40,000 students with special education needs, and about 580 principals. Do the math. You want those principals re-explaining the same thing to every single one of those families, they're not going to have time to, be a principal. But on top of that, lots of those principals don't actually know this information. And if we're having trouble finding it, they could have trouble finding it. It's a big school board. So we put this together in and staff weren't prepared to go any further on this. So we put together a recommendation, which we passed in June of 2016. That's 10 years before I'm recording this video. We explained the problem, and we said the board should have a comprehensive communication strategy to explain this information in plain language. And we spelled out the kinds of things that they should explain in it. Board did nothing. They really did nothing. A couple times they came back to us and said, here's our leaflets, what do you think? But it was pretty much useless. So 2 years later, I get on the Special Education Advisory Committee, and I put this on our agenda. And I present what our TDSB SEAC had passed and suggested we should be recommending something like this provincially. Well, around the table, there was agreement that this is a problem not only in Toronto, but across the board, across the boards. But our committees weighed in and said, well, let's refine it. The recommendation here is a good starting point, but let's add to it. And they did. Made it better, and it banged right there in the K-12 Standards Development Committee report that came out in 2022. Well, we then, so this is a problem that we identified in this Toronto committee. The school board didn't do anything about it, but I've now got it endorsed by a government-appointed expert committee for province-wide adoption. Now, go back to, now that's 2022, that report comes out. I'm now not the chair, but a member of the Special Education Advisory Committee still at TDSB. I proposed that we set up a K-12 working group to work on getting it implemented. We got a motion passed recommending that TDSB should do all it can within its mandate to implement the report of the K-12 Standards Development Committee. Senior bureaucrats said, oh, well, we're waiting to hear from the province. Well, we'll die of old age. And you don't really need to wait to hear from the province to know you got to obey the Human Rights Code, and that's frankly what all of this is about. But in any event, we then set up a K-12, as I said, working group, which I chaired within the Special Education Advisory Committee. I circulated the recommendations that had been provincially recommended, that built on what our own SEAC had recommended. We sat down with some staff people, said, what are you going to do about it? We didn't really get as far anywhere near we'd like, but we actually went through the website with them and went through their brochures and line by line showed what the problems were, summarized it. Again, they came up with some new videos, though the videos still were full of jargon. So in the couple of years ago, in spring, in the summer of 2024, I believe it was, we passed a motion at my recommendation, the Special Education Advisory Committee, basically saying, we've raised this for 10 years. We're not getting anywhere. We need more. Here's what we need. And we couldn't get the staff to move. We kept raising this. And that fall, I presented this to the trustees. This is before the province took it over. The trustees around the table were echoing the concern. They hear from parents. They tried to get, I tried to get them to pass a motion that would say it is a priority for staff to come up with a strategy to fix this. I thought that's within the governance role of those in an elected trustee role. The staff went back and said, oh, that's all operational, which is nonsense. They got them to pass a motion that said that the Toronto District School Board Director of Education should consider whether it's a priority for parents to know what's available for kids with disabilities and special ed needs. The then acting Director of Education said, well, it is a priority for me, but aside from releasing videos that have don't even use the word disability, and a couple of other minor changes, the problem persists. I was ready to go back to the trustees in the fall of 2025 and say, you gave them a year, it's not been fixed, we need more vigorous action from you. Unfortunately, a couple of months before I was going to do that, the provincial Minister of Education took over the school board, ousted the trustees, appointed a supervisor. I have met with and written that supervisor to say, this is a priority. You're now the provincial supervisor. You're now running the board. Could you fix this? Nothing's changed. So do we have our work ahead? Absolutely. But is this an illustration of how we can take these platforms, consolidate our message, and advocate for it through an avenue that I thought wasn't worth the time? And in thinking that early on, I was completely and utterly wrong. Next lecture, let's turn to the specifics of how you take your issue to the government. How do you advocate to a big government bureaucracy? We'll see you then.